One of the most important concepts in contract law is whether a party performed its obligations under a contract or whether it breached. This matters for two reasons. One is that a party who didn't perform as promised is liable for damages for the breach. And the second reason is the other party, the party to whom performance is due, is not obligated to perform under an exchange of promises if they have not received the benefit of the bargain. So we have to ask whether a party performed or breached a contract, and the answer to that question is it depends on a five-factor test set forth in the Restatement Second of Contracts, Section 241. This video will take a deep dive into this important five-factor test and explain how each of the factors equates to whether or not a party should be found to have substantially performed or materially breached. In other videos, I talk about the effect of substantial performance and material breach. But first, this video is going to focus on simply distinguishing between facts and circumstances which would lead a court to conclude that there has been a substantial performance, as opposed to the facts and circumstances for material breach. In other videos, we'll talk about the legal effect of this distinction. But the test itself is somewhat complicated, so let's go through it in detail. The test for whether there has been substantial performance or material breach is set forth in the Restatement Second of Contracts at Section 241, and it turns on five factors. First, the extent to which the injured party will be deprived of the benefit which he reasonably expected. Second, the extent to which the injured party can be adequately compensated for the part of that benefit of which he will be deprived. Third, the extent to which the party failing to perform or to offer to perform will suffer forfeiture. Fourth, the likelihood that the party failing to perform or to offer to perform will cure his failure, taking account of all the circumstances including any reasonable assurances. And fifth, the extent to which the behavior of the party failing to perform or to offer to perform comports with the standards of good faith and fair dealing. That's the language directly from the Restatement Second of Contracts, and sometimes pure black-letter rules of law are hard for law students to understand. So let's break this down and simplify these concepts. Before I get there, I apologize in advance for using some funny names in this next section, but just to define them, I'm going to talk about the obligee and the obligor. The obligee is the person to whom an obligation is owed. The obligee is owed an obligation by the obligor. Until that obligee receives the promise, the obligation, the obligee may withhold its own performance under an exchange of promises. The obligor is the name for the person who owes the current obligation, which is at issue. And this is the person whose performance is being judged. I use these funny terms, obligee and obligor, because they more accurately represent the situation, which is that both parties have obligations to each other. What we're focusing on in doing this analysis is whether the party whose current obligation may or may not have risen to the level of substantial performance or complete performance, that's the party who's being judged. That's who we're looking at. Once that party performs, then the other party, their obligation becomes due as well. And so they actually switch roles between obligee and obligor as performance occurs. I hope that helped. Let's get into it. Restatement Section 241 sets forth a five-part balancing test to distinguish between substantial performance and material breach. I've simplified it, and now let's go into each of the five factors that go into this balancing test in some detail to make sure we really understand how to conclude whether there has been substantial performance or material breach. The first factor is the extent of the obligee's deprivation. In other words, to what extent was the injured party harmed? To what extent was the injured party deprived of the benefit which he, she, or it reasonably expected from the exchange? The greater the extent of the deprivation, the more likely we are to find material breach. After all, the purpose of distinguishing between substantial performance and material breach has to do with whether the obligee needs to perform its role in the bargain. And we find that under an exchange of promises, a party has an implicit understanding that he, she, or it does not have to perform his, her, or its benefit of the bargain if he, she, or it does not receive the substantial benefit of the bargain from the breaching party. So the greater the deprivation of the obligee, the higher the likelihood that the court will find there has been some material breach. The second factor is whether the obligee, the non-breaching party, the party to whom the obligation was due, can be adequately compensated for the loss at law, whether the obligee has remedies at law. The adequacy of compensation of loss matters because if the parties are in a situation of material breach, the obligee can engage in self-help, meaning the obligee can refrain from performing lawfully in order to cause the other party to perform its obligations. On the other hand, if there is substantial performance, then the obligee must perform its obligations in turn and has to sue for the difference. Therefore, if it's difficult to sue for the difference, we are less likely to find that there has been substantial performance. The greater the ability of the obligee to find a remedy at law, the lower the likelihood of material breach, because the more effective substantial performance will be in resulting in both parties getting either the benefit of the bargain or adequate expectation damages. The third factor in determining substantial performance or material breach is the forfeiture of the party who failed to perform. In other words, what is the extent of the obligor's forfeiture? This is effectively balanced against the obligee's deprivation. In other words, how much will the breaching party lose if the non-breaching party is not required to perform its mutual promise? If the non-breaching party is only harmed a little by the failure to perform by the obligor, and the obligor be harmed a great deal, courts might find it unfair to call this a material breach. So, the greater the extent of the obligor's forfeiture, the lower the likelihood of a court finding that there has been a material breach. The fourth factor in distinguishing substantial performance from material breach is the obligor's likelihood of cure. In other words, how certain or uncertain are we that the breaching party is going to fix their defective performance and raise it from the level of material breach to substantial performance? If we feel pretty confident that a party is going to perform regardless, if the breaching party is really making efforts to try to cure any defect in its performance, there is less reason to conclude the failure is material, because we don't need to run to courts to fix the problem. Instead, the parties will probably solve it for themselves. This also relates, as we'll see in a moment, to good faith. But the key thing is that the greater the obligor's likelihood of cure, the less likely that courts will find that the breach is material. The fifth factor in distinguishing substantial performance from material breach is whether the parties have acted in good faith and with fair dealing. Although the restatement frames this as focusing on the obligor's good faith, my reading of the case law as well as the comments to the restatement suggests that actually both parties' good faith matters. Basically, the party that's not acting in good faith is unlikely to win the court's favor. So, the obligor, the person who failed to perform, they want to get paid. They're trying to convince the court there has been a substantial performance. The obligee, they don't want to have to pay or perform. They're going to try to convince the court that there has been a material breach. Therefore, if one or both of the parties is acting in bad faith, the court is less likely to award them the remedy that they seek. To put it yet another way, if the obligor is acting in bad faith, then there is a higher likelihood that we will find material breach. On the other hand, if it's the obligee who is acting in bad faith, then we have a higher likelihood of finding substantial performance. Let's put it all together and weigh whether the factors counsel for material breach. All of this will be in the context of whether we will find material breach. And so a plus means higher likelihood of material breach, a minus means a lower likelihood of material breach, and a higher likelihood of substantial performance. First and foremost, the obligee's deprivation. The greater the extent of the obligee's deprivation of benefit, the higher the likelihood there has been a material breach. Second, does the obligee have alternative remedies? If the obligee has good alternative remedies at law or equity, this will decrease the potential for material breach. Third, whether the obligor suffers a forfeiture. The greater the extent of the obligor's forfeiture, the lower the possibility of material breach. Fourth, whether the obligor is likely to cure. The higher the obligor is likely to cure anyway, the lower the likelihood that a court will find material breach. And finally, fifth, whether the parties are acting in good faith has a great deal to do with whether they merit a remedy at all. If the obligee is acting in good faith, this will increase the chances that the obligee will get the material breach decision they are seeking. On the other hand, if the obligor is acting in good faith, this will decrease the extent to which a court will find that there is material breach. And there you have it, how to distinguish between substantial performance and material breach. You apply the 5-factor test in Restatement Section 241, and using this test you can determine whether the parties are entitled to the benefits of the bargain or whether they have to sue for any difference between what they expected and what they received. Thanks for watching, and tune in next time.